The credit bureaus must investigate errors because there's state and federal statutes that require them to do so. Our credit bureaus are trusted with an immense amount of data associated with our everyday financial lives. Because they've been entrusted with that data, the Congress and your state legislature requires that if there's something wrong with the data that's within their possession and the consumer notifies them of that error, the credit bureaus themselves are required to do an investigation to see if the information on your credit report is in fact correct and is incomplete and accurately reflects who you are in your financial life. Quite often when consumers are submitting disputes to the credit bureaus or even to the banks that they have a relationship with, there's some stall tactics that we'll see utilized. So for example, the credit bureaus will say that, well, we got your dispute and we don't have an account on you, yet you know that not to be true. Or they'll say that you need to provide additional information, which would be like a driver's license or something you already provided. So as frustrating as that is, we always advise our clients to play the game, send them the additional information, because if you've given them everything they've asked for, substantiated your dispute, showed them who you are and why this information in your credit report is incorrect, the bank and the debt collector and the credit bureau are going to have some very, very tough questions to answer in front of the jury when it comes to trying to justify what they did upon receipt of your dispute. The complaints that are filed against the credit bureaus are filed in federal court. This is because most often we're utilizing federal statutes to initiate this lawsuit against the credit bureaus. I recommend using a consumer protection firm, whether it's my own at Local Law or another, because federal court is very formal. In terms of filing a lawsuit against a credit bureau, I'd recommend filing a lawsuit once you've given them a dispute that really clearly told them what the issue was. You don't want to rush to the courthouse if it's only been a short dispute or an unclear dispute, because what you're doing in that scenario is you're giving the credit bureau an easy defense because they only have to conduct a reasonable investigation based upon the information they received. So if they received unclear information, it is easy to do a reasonable investigation at that point. However, if you open up a Word document or grab a piece of paper and just explain everything you know about why this information is inaccurate, and you back up that story with documents to show where you were or why this information is inaccurate, that's when you have a very strong claim, and I'd recommend bringing the lawsuit at that time, once that strong claim is rejected. To substantiate a dispute, what the consumer needs to do is substantiate their claim. One such scenario that we saw is there's a particular fraud ring that for whatever reason was targeting our service members. And what they would do is contact the service members and obtain their information through lies, through what we call social engineering. From there, the fraud ring was opening up accounts in these consumers' names. So we get into litigation and we see that these accounts were opened when at least one of our clients was in Bahrain, flying fighter jets. Yet while he's up in the air, according to his flight logs, accounts are being opened in the state of Washington, completely fraudulent, completely without his consent, and completely without his knowledge because he's trying to focus on flying these sophisticated planes. So we're able to unequivocally prove that this was not his and that it's purely fraud, which resulted in a strong recovery for our client. If you find yourself in a situation like this, where you can explain that this is not your account, this is not your fraudulent transaction, give Local Law a call and we can take it from there.